Well, good morning, everyone. Thanks for joining us today. We're really excited. We have a special speaker here today on this very blustery, freezing cold day. I know I actually took my son out to school this morning when my hair was still wet, for the bus, and it actually froze. It really did.
Oh,
it was still
terrible.
I know. This is about the time of year where I'm hoping, well, I don't know. I would like to be sitting on the beach, but we're not. So.
Yes.
But I hope everybody's doing well, staying safe and warm. We have Rachel Lozosky here today, who's an attorney and partner at the firm of Peacock, Keller. And Rachel and I have known each other for some time. She's done some great work for clients as well as for us. And she concentrates her practice on employment law and school law. And she represents both employers and employees, including small and mid-size and large profit and nonprofit sectors. And her firm is, like I said, located right here locally in Washington. I mean, they're a full service firm, but they do have some other offices in South Point, Bridgeville, Claysville, Waynesburg. And I can't believe this, but I still haven't seen your new South Point location.
Yes.
And I don't think you've seen our new location either yet, have you?
No. And I was supposed to today, but we'll get to that in a minute. It still didn't happen. So
that's okay. That's okay.
Yes.
But I mean, your resume is so long. I mean, I know you've represented many public school districts as solicitors. I know you're active in the community. I mean, you were the president of Zonta. I know you were involved in Power of South Point, the Rotary, the chair of the Washington County Bar. You were an Athena finalist at one point. So you have a very, very long list of credentials. And I know you're also a great person and you're awesome with the employment law. So today, Rachel is going to be talking about some of these employment transitions and some of the trends that are happening in employment. I think a lot of us know that's changed. Many of us have either changed jobs or COVID has impacted us in some way. So she's going to be a wealth of information, I promise you, and here to also answer any questions that we have. So as always, we like to keep this interactive. Rachel has some things she's going to talk about, but at the bottom of your screen, if you have a question, please feel free to raise your hand at any time, or you can use the little chat button. And I'm going to be monitoring that. Rachel, I'll let you know if anybody has, a question. So we're here to answer all your questions today. I'm going to stop talking and let Rachel take it away with some of these interesting topics that we have.
Okay, thank you so much, Melissa. And I'm really excited to be here talking with Melissa today. Melissa is a much admired colleague as well. Like she said, we've worked together over the years. We've been involved in a number of organizations together over the years. And I was so looking forward to being in her office and seeing her new office and spending some time together in person. We were just discussing how we're so tired of doing exclusively virtual meetings. But as is the world we're living in, I had some symptoms. I certainly don't want to put Melissa or anybody else at risk. So I got my test this morning, feeling reasonably better. Definitely can get through this webinar. And so that's why you're seeing a blurred view of my kitchen instead of a lovely office background. But it ties in, I think, rather well to what we're talking about today, because we're going to be talking about evolving and moving into this new workspace in which we're all living, which includes remote work, of course, and the legal issues that go along with that, and also the legal issues that go along with job transitions. And in the last few years, I've definitely experienced an uptick in calls, new clients calling our office because they're looking to move between jobs, sometimes voluntarily, sometimes unfortunately not voluntarily. But I've been fortunate to be able to help those clients. And then on the employer side, a trend that I'm actually seeing, despite the doom and gloom that we hear about the economy, I've been seeing a lot of small to mid-sized businesses really poised for growth. So that certainly is gratifying to me. And it gives me kind of a more positive outlook for my private clients, my individual employee clients, knowing that growth is out there and they have some opportunities for movement into good companies and nonprofits that are looking to expand.
Well, that's really positive and encouraging. I mean, I was hoping you could talk a little bit more about transitioning between jobs or career fields. Um,
Sure,
because we
sure.
have
And
a
there's
lot of clients in that situation, obviously, and that's kind of what prompted us to have these conversations to begin with.
Sure, sure. And I'm sure that clients are coming to you as they're looking to, adjust financial plans in that situation. And equally, both on the employer and employee side, folks are coming to me and I'm talking about it from the legal standpoint. And one of the first things that brings someone to my door is a severance agreement. So you have either an employer who's looking to cut ties with someone and they're wondering, what's the best way to do that? Should we have a legal document for that? And we have employees who want to know, is this severance agreement that I was given fair? Is it legally sound?
Mhm.
And usually the basics are someone is being offered something, in conjunction with the termination. So they're either being offered a severance payment, maybe some unpaid vacation time, something along those lines. And there's really no one size fits all as to what is fair. That's a really tough question to answer. It depends on a lot of things. It depends on how long someone has been with an employer, what their record of service has been. Have they had difficulties? Have they had disciplinary issues? And what really were the conditions surrounding leaving? And then people ask me, is it legally sound? Of course, right? That's why you're coming to a lawyer. And that's very tied to the issue of whether it's fair. So for a severance agreement or any contract to be legally enforceable, there has to be some consideration that passes. And all that means is one side gives up something and receives something, and the other side does the same. So when you're looking at a severance agreement, in Pennsylvania, we are an employee at will state. So unless someone has a contract that provides otherwise, they're not entitled to receive really anything at the time of termination. Now, there might be a contract, there might be a policy that says otherwise. But if not, anything they receive of value, is in addition to anything the employer had to give. So for the document to be enforceable, that employee has to be giving something back. And typically what they're asked to give is a release of all claims. I will not sue this employer based on the circumstances that surrounded my firing or my layoff, my termination. I will not come back and sue for anything that happened while I was employed. I will not allege that I was, discriminated against unlawfully, anything like that. And so the value of what's passing on both sides is really going to be a case-by-case determination. If someone thinks that they have a good cause for unlawful termination or discrimination or anything along those lines, to give that up, that's worth more than, if they're simply leaving on very good terms. So in that case, someone might ask me to negotiate for a higher severance and say, hey, employer, we believe that we don't have to sign off on this. And if we do, we want something pretty good in return.
Can I ask you to stop you for 1 second?
Sure.
How negotiable are those agreements? Because I think a lot of times clients feel, I mean, they're in such a vulnerable position to begin with when this is happening. I mean, they're losing their job.
Right.
They just are afraid to suggest anything because they're afraid it could be taken away from them. So, I mean, what's the likelihood they would succeed, and do people negotiate, and does it actually work? And if they don't succeed, are they still entitled to the original offer?
Well, that's a very good question. And I'm asked that very, very often. And it is, again, it's very case by case, because again, your starting point for an employee at will is you're not entitled to anything.
Yeah.
The employer could fire you for any reason. So they can pull back an offer, and the odds of it being negotiable, it really depends. Both sides are, it's like any negotiation, right? Both sides are deciding when to show their hand. They're trying to understand, what their hand is. So if I'm counseling an employer and I'm saying to that employer, you might have some liability here. There were things during the course of employment you didn't do so well. That's going to be more negotiable, from the employee's side.
Mm-hmm.
When I'm talking to an employee, sometimes what I have to tell them is, to some extent I think bluffing is too strong of a word,
Mm-hmm.
but until you actually get into a lawsuit, you don't have a right to discovery of a lot of information surrounding things that went on at the job. So to some extent, you're trying to say, I think I have some leverage here. And the employer can kind of, both sides can kind of play a bluffing game for a while. So it really depends on, and it depends on what kind of counsel both sides are getting too.
Sure. It seems like in general, though, the employees are really they're not in an equal position, I think, from a negotiating power standpoint as the employer, generally speaking. I mean,
yes, generally speaking, that's fair to say. But there are some things, and this gets into something else I know you wanted to talk about. Sometimes a non-compete. I have seen non-competes that are written in a way that really is too broad. It's not enforceable. So that can be an area of negotiation where you can say, hey, either I'm going to, as an employee, soon to be former employee, either I'm going to go to court and try to have this modified or found unenforceable because this non-compete is too restrictive, or you're going to pay me a severance that makes it worth my while to abide by this very restrictive non-compete for 1 year, 2 years, however long it may be.
Mm-hmm. Okay. So from the standpoint of like employee evaluation, like when they're separating service from a company, you think always wanted to have somebody review that severance agreement, or at least you think in general that's a wise thing to do, and that it may or may not be negotiable, but I mean,
Correct.
That's typically going to be part of it can be part of a separation.
For sure. It's at least good to know what you're signing, even if you can't negotiate.
Okay. I mean, is there anything else you wanted to add about like transitioning or severance agreements or?
So severance agreements and non-competes are related. A non-compete can be included in a severance agreement.
Mm-hmm.
It can be something that an employer gives an employee to sign at the beginning of employment.
Mm-hmm.
It can be a standalone document that's given to someone throughout the course of their employment. If it is not something that's signed off on at the time of hiring, then the employer has to give you, we're back to consideration, has to give that employee something in return. So if all of a sudden 2 years into employment, you want to hand your employee a non-compete, you need to give them a bonus or something of value for the restriction they're doing in return. And non-competes, they really can be all over the board. And I know you and I have talked about this several times, just thinking about them in general and questions that you get from clients. And generally, you want to look at geographic scope and the time frame of a non-compete. Generally, anything beyond 2 years is going to be viewed by a court as too restrictive. Geographic scope, that's a really interesting question. And I know you and I have discussed this, again, just generally lots of times. That depends on the context. So, one really simple example, you hear that a non-compete is a 30-mile geographic span. And you might think, well, that sounds pretty reasonable, but just kind of a silly example, but I think it illustrates it. Let's say that you are leaving employment with a surf shop in Hawaii, and you have a non-compete that says that you can't work for any competitor for 2 years within 30 miles. But every surf shop of that nature that sells what you have worked on and what your skills are related to is within 30 miles. That's very different than a non-compete, in a different setting. So that might not be enforceable.
Well, I think that comes up in Pittsburgh a lot, actually, because everything really isn't, it might feel far because it takes 45 minutes to get to the North Hills. But the reality is a 30-mile radius around Pittsburgh is not, I mean, it encompasses a good amount of the suburbs. So
it does.
You do have to be careful with that.
Yes, it does.
I think the important thing is, at least what I see with our client base is, one is that people are afraid when this is happening to seek legal advice. And I think that that's probably not the best idea, especially with these non-competes, right? Because
that's right.
We even had a situation recently where it turns out someone was sort of put in a high pressure situation to sign one of these. And then because it was just poorly written, it wasn't even enforceable. And they wouldn't know that. And asking, Joe Schmo attorney down the street or their friend that knows, it's not the same as getting the real legal advice. And that person may have made life decisions that were different from them if they hadn't had it reviewed by somebody.
Well, that's absolutely right. And, just as someone who is looking to make some serious decisions about their retirement planning, probably should not just go by a general Google search. They should talk to someone like you. It sounds very trite. You shouldn't rely on WebMD, for your medical advice. But I tell you truly, particularly with non-competes, I mean, even I, as an employment attorney, often have to sit down, spend considerable time reading, rereading. There are so many nuances to them. Just one example, a non-compete can say you can't engage in a competing business, but then it doesn't define what a competing business is. There are so many parts of that you can be trapped either violating it and maybe losing a benefit, or unnecessarily restricting yourself when you didn't really need to.
Yeah. So I know this may be off topic a little bit. I mean, it's related, but you might not know the answer right off the bat. But we have a lot of clients, and I see this happening in our client base, but I also know from economic data that comes out there's other measures of like non-farm payroll and things like that indicate there's a lot of people that left the workforce that are starting businesses again. So they're now becoming like subcontractors, 1099. So some of those things haven't showed up yet in the numbers, but we know that it's happening. I mean, I could probably count 10 or 15 clients this year that left their employers and are starting some type of gig on their own. If they had a non-compete with that employer, does that apply when they're a subcontractor at that point? Or is it only if they're an employee of another company?
It very well may apply. And again, it requires a really careful reading of the non-compete.
Okay.
Yeah.
All right.
Yeah.
So, I mean, those are all definitely important considerations with people transitioning between jobs and for employers too. I think would be ready to shift gears to talk a little bit more about remote work and some of the COVID stuff that's been impacting people, because I think that's probably another big thing on people's minds.
Sure, absolutely. I think a lot of people think that they know everything there is to know about remote work now, right? We've struggled through this for approximately 2 years at this point, off and on. But I have found that a lot of employers are just now really looking to get a good work from home policy in place, because we've just all spent a lot of time adapting to this sort of in motion. And so I think both sides are still a little unsure about what the rules might be. And sometimes there is a sense, because we've all become so accustomed to this, that there is some right, that employees have to work from home. And that is generally not the case. It could be the case in some limited circumstances, if it's an ADA, Americans with Disabilities Act issue, someone needs to work from home as an accommodation. And that's a whole separate type of discussion that an employer has to engage in, not just for working from home, but any kind of accommodation. But generally, there is not a right to work from home. But where this can get a little tricky is if an employer decides to grant that as a benefit or a privilege of employment, then just like any other benefit or privilege, it needs to be applied on a fair basis. It cannot be discriminatory, certainly by intent or even by practice, by effect, by implementation, let's say. So my best advice, and employees need to understand this as well, although it sounds like I'm really just talking about writing the policy, my best advice is that employers take a stance that, generally this is our right to allow or not allow remote work, but then we're going to set some parameters so that if that question comes up, why was this person allowed to do it and I wasn't? It's not because of your gender, it's not because of your age or your race or religion or whatever it might be. It's because we had these parameters in place and you didn't meet them. So
from an employee's perspective, then I guess conversely, I mean, I hear a lot more of that. Well, I don't know. I hear both sides. It depends who I'm talking to, but I think a lot of employees are concerned that, they've earned the privilege of being able to work from home for maybe even a hybrid, like 3 out of the 5 days. And it's gained them a lot of flexibility in their life, a lot of work-life balance, and they want to keep that. So from their perspective, like say that their boss granted them permission to do this, you know, what kind of negotiating power do they have, if any, or like any advice for them, you know, because I know that those rules are changing a lot. They're not necessarily always happy about it. So there's probably a healthy way to go about doing that, where they could be effective, like, and talk to their employer, and maybe a not healthy way of doing that. So,
Sure. Sure. So I think anytime that an employee takes kind of an entitlement stance, I deserve this and it works, that you can try that. There's no legal
right,
reason why you can't, but it's not the best approach from a practical sense.
right.
From
Because
a
they have attorneys that are advising them on how to make sure that doesn't happen, right?
That's right.
Yeah.
That's right. And from a practical sense and a legal sense, they're really tied together. The best kind of practice and policy that an employer can have is to say, first of all, work from home is going to be allowed if it advances the business needs of the company. So anything that's based on legitimate business reasons generally is going to be legit. So from an employee's standpoint, that's how you'd want to approach it. This is why this makes business sense. I'm actually more productive when I work from home. I'm able to have the flexibility to, not take 2 hours off to go pick up my child. I can, take
Right.
20 minutes to run down the road. Try to show the employer why it makes business sense.
So in that case, as an employer, you can be using it more to incentivize employees that you want to keep and attract than making it a hardline policy of this is how we're doing. Is that fair to say? I mean,
It can definitely be an incentive, but you just want to make sure that you apply that incentive evenly.
right.
So if you have 3 people who have performed equally well and their jobs lend themselves to remote work, you
Mhm.
shouldn't be picking arbitrarily among those 3. If it truly is an incentive and all things are equal, then those 3 should be allowed.
Okay. All right. Well, that makes sense. I mean, are there any other rules for remote work that employers may want to require and that employees should anticipate that we haven't talked about? Or
Oh, sure. There are many rules, and the starting point is really that every rule that applies in the office can apply at home, unless it is so far outside of adapting to remote work. But just as when you're in the office, your employer can monitor your work, they can monitor your internet usage, your use of their computers and their equipment. They can do that at home. They can remotely monitor your use of all of their equipment during the day. They certainly can require that you keep everything confidential. They shouldn't really go as far as to say, you have to have this type of workspace. We designate that it must be however many feet by however many feet, but they can definitely say it needs to be a safe, confidential, appropriate workspace. And believe it or not, an employer actually can come to the home and inspect and make sure that their materials, their information, everything is being handled appropriately.
hmm, I don't think I would have even thought about that. And probably most people don't realize that either.
No, and I don't know anyone who has exercised that right, but I have written it into policies, just to give that flexibility if it's needed
Yeah.
to an employer.
I mean, if an employer is, I don't know if you know this, but if an employer is asking someone to work from home, are they required to provide them equipment?
Generally, it would make sense to do so. Yes. Yeah.
Because they can't really do their job without it.
I mean, right. If it's a requirement and you're not giving someone the tools to do their job, how can you really
Yeah.
fault them for that? So generally, yes.
So what if the employee got hurt at home?
That is such an interesting question.
It is an
And
interesting.
it
I
is,
know.
it is a really interesting question that I just had to take a look at recently. So if the employee is hurt while they are working, generally in their workspace during the hours of work, or taking what is called under workers' comp parlance a comfort break, most generally that would be covered by the employer's workers' comp coverage if they have it. So if it's the kind of break you would take in the office, I think this is really interesting. If I were to walk to my Keurig, if I'm to take a quick break to step outside, and that's generally in the course of the workday, probably covered. But if you take a break to pick up your child at school and you're in a car accident, or you take a break to walk out to the mailbox or walk the dog and you fall, if that's not generally something you would be doing in the office, then it's most likely not covered by workers' comp.
Okay. So from the standpoint of like remote work, any other considerations there that employees should be thinking about?
I would advise employees and employers try to be, as close to the work expectations within reason, that you have in the office. If you're an employee, just know that your employer can definitely require that you are, working at certain times. If it works well for you to be more flexible, you can talk to them about that. But if you need to be near a phone or near email during certain times, then that can be required. You need to make sure that you are expending the same amount of effort, good effort. If you need flexibility to do that in different ways, to do it at different times, talk to your boss and make sure that you have those rules of the road established and everybody understands that, so that generally your product, while it may look a little different, in terms of the times of day that you're doing it or anything else, overall, everybody knows what the expectations are and that your quality output and your quantity output remain the same. Because the more that you can show that it works, and again, it comes down to, does it make business sense for the employer? The more likely you are to be able to keep that arrangement. It requires communication. It requires, some flexibility with expectations. But then once those expectations are decided on, really then holding to that and keeping that, as clear as possible.
And it's probably fair to say that employers need to be as clear as possible too, because I'd imagine that throughout this process, some of the communication's probably been a little bit confusing. I mean, nobody really has, it's kind of been coming and going. There's just, it's evolved. So
yes, that's absolutely true. And that's what I'm seeing now on the employer side, that we're trying to get to a point where, okay, we can kind of regroup on this. And if this is something we're doing, not just in response to a crisis, but, maybe something that works going forward, what are the real rules of the road here, and if there's going to be flexibility, how does someone ask for that flexibility, and how do we establish? It's all about within a reimagining and within some new framework, still then saying, okay, these are the expectations, however altered they may be.
Yeah, that seems like common sense as well as good legal advice, right? That's anytime you're trying to, whether you're an employer or an employee, setting the expectations and trying to make those clear, that's going to only result in a more positive situation. Definitely.
That goes for remote work. That goes for work anytime, any place, on both sides. Yeah. So I hope that's helpful.
It is helpful. Does anyone have any questions? I haven't seen any questions pop up. People are usually pretty shy about questions, but I like to stop and ask, because sometimes people have their own thing that they're thinking about, and that's why they hopped on the webinar. So I'll give them a minute to respond if they want to. You can just, by the way, just to remind you, go down to the bottom of your screen and hit chat, or you can raise your hand if you want to ask a question. But I know we didn't talk about this specifically, but with COVID, as far as if you get COVID and you're an employee or an employer, are there certain rules or criteria that are set across the board, or is it basically at the discrimination of that particular company? I think a lot of people do have questions about that. Do I come back to work? Do I not go to work? What does my employer expect? Right. Is there? A lot of employers probably don't have a written document explaining.
Right.
Maybe bigger ones, but I know we've thought about that, and we should probably think through that a little bit more. What is the policy?
Sure. So the only overarching, policy that exists sort of out in the world would be the CDC guidelines. And most employers seem to be sticking with that.
Okay.
But then they will often reiterate. And if an employer hasn't done this, I think it's a good idea to do so. If the employer's expectation really is, if you have any symptoms, we don't want you in the building. It's like we were saying about everything else, communicate that, make that rule clear, and then make it clear what you're supposed to do. Who do you notify? What do you do next? How long do you stay home if you don't test? How long do you stay home if you test positive or negative? Those were really tough questions, I think, early on. I think by now, everyone has a sense of basic CDC guidelines. They know how to get that information, put it into a policy, recognizing that changes and also
Sure.
drives us all crazy.
Well, and the CDC website is good. I feel it has,
Mhm.
the guidelines are clear, but how to implement them, like some of those questions you just asked, I don't think they're on, some of them aren't on there.
No,
Yeah, and you're like, okay, wait a minute. So I know I personally have run into these issues. You're like, you have this exposure. Do you go to work? Do you not go to work? How long? It doesn't tell you exactly what to do step by step. So I'd imagine
no,
as an employer, it's probably, it would be
correct.
helpful to be even more specific than that.
I
Okay.
think so, because I think it's by design that the CDC doesn't want to interfere too much in saying exactly how a business responds.
Yeah.
CDC is saying, here's when a person, whether it's employee, anyone,
Mhm.
should isolate. Here's what that should look like. We're really trying to leave it to businesses, to use some common sense to implement that. But I think by this point, every business should have some procedure for who do you notify, um, and letting people know, if it is okay and indeed encouraged or required, that you stay home, that you follow these steps. Um, when masking is required upon return, people really, they want to know those rules.
I know.
Um, so
Yeah,
they want to
that's
need to know those rules. And taking leave as well. Early on in the pandemic, there was an emergency relief law passed that provided for paid and unpaid COVID leave, and
I'm
that has
so glad you
expired.
said that. It's
Yeah,
gone. That's actually what prompted the question on my part. I was
yeah,
wondering that, is that still, because I haven't heard about it since then. Is that like, are you required as an employer to grant that, or do they have to use PTO, or like, how do you even begin to address that with employees? I mean, you don't want someone eating up their entire vacation because they had
right.
COVID. I mean, that's not, I feel like as an employer, that would be unfair.
Right. There is no longer a mandate for that time. There is no longer a federal or state mandate for paid or unpaid COVID time off.
Okay.
So it's up to the employer. And it's going to vary employer to employer. If your folks have a lot of sick days, but a lot of companies are moving more toward just a flexible PTO that's to be used for sick,
Yeah.
personal, vacation, whatever. So there's nothing that prevents you as an employer from being flexible and allowing more time off in those circumstances. But you just want to make sure if you do it for one, then the person in the same
Right.
circumstance you treat the same way.
But also, I think taking into consideration not just the legal aspect, morale. I mean,
Right.
if someone is entitled to 14 days of PTO and you wipe 10 of them out, I mean, how are they going to feel about their job for the rest of the year? Is that really the best decision for the employer either? And I would probably say no. I guess also now, especially with these like the people are able to be vaccinated, if they're not unwell, they might be able to just stay home and work, and they wouldn't have to take PTO. So employers could certainly give that flexibility as well.
Absolutely.
Okay.
Absolutely.
I
Yeah.
have a great question. Somebody has a great question over here. Can I?
Sure.
It says, what is my responsibility as an employer to tell the staff that another staff member has COVID? This is a good one. Is that a violation of the employee's privacy? That's a really good question, because I've run into that too.
Yeah, that's a very good question. And generally what we recommend is if there's any way that you can keep you can relay the information. Well, first of all, you should ask the person who's positive if they care about having their name
Right.
released, because my experience in my offices, no one seems to care.
Right.
Everyone says, release it, let everybody know it's
So
fine.
90% of the time, it's just a non-issue.
90, yes, if not more than 90%, it's been a non-issue. But if it is an issue, you can give as much information as necessary to protect your other employees. And generally, there's a way to do that. You can say, someone who worked on this floor, within this area, within this building, tested positive. If you need more information, come to us. There are ways that generally you can tell someone in a way that allows
But if
them
they're
to,
not there, it's pretty clear who it is, I would admit.
and it becomes pretty clear. It
Right.
becomes pretty clear.
Okay. Okay. Oh boy, I don't have any other questions. I don't want to take them. Does anyone else have any questions? And most importantly, Rachel, do you have anything that you'd like to add?
Really have much to add other than adaptability. I think that is, we're talking about your work life in 2022, and we go through a lot of legal rules, but I think the overall concept is adaptability. but also balanced with the principles that do not change. So there are many, many things to which we need to adapt. But the basic principles of being a good employer, being a good employee, that we've talked about, being clear, knowing expectations, meeting expectations, asking questions when you have them, and trying to do everything, really for the good of your job and your business, those don't change. So we adapt and we keep consistent the things that work. And I think that's the best we can do moving forward in this time that continues to be strange and crazy and interesting and
Yes.
always new. So
I think that's very good advice. I mean, and really, if people just follow those basic principles, then the result can be good, no matter what kind of all these little legal nuances are, right?
exactly.
I can appreciate that as well. I mean, I want to sincerely thank you for all of the information you provided us today. I mean, this is super helpful, and just for always being a resource to us. And I also want to thank everybody for joining us today. If you have any questions specifically for Rachel, I'm sure she'd be happy to take them. We are going to be sending out a recap of what we talked about today, and also there'll be a little link with the recording of the webinar and some resources on it, as well as her contact information. And you're always welcome to call Stein Malt Advisors too. So we appreciate everyone joining us today. We know that people are kind of zoomed out probably a little bit, but also taking time out of your busy schedule. We're always here as a resource, and we'll continue to do these webinars on a regular basis. And if anyone has any idea for topics, we're all ears. So thanks, everyone. Have a great day. Thank you again, Rachel.
Thank you. Thank you for the opportunity, Melissa. Have a great day, everybody.
All right. Bye.
Bye.